I recently got the question, or I got a question from a friend who asked, Paul, I just got married. What sort of stuff should I have in place as far as estate planning? So there's a common misconception that estate planning is only for older people, people who have kids, people who have a lot of assets, they've lived a long time, maybe health issues are becoming more apparent, but that's just not the case. So the reason for that is estate planning is really taking away the state's default rules. It's creating your own rules so that you're not relying on, or your family's not relying on, the state's default rules. So when you're a married couple, you would assume that should you die and you have nothing in place, the surviving spouse would just take it all. They'd be the 100% beneficiary of your estate. Well, in North Carolina, you'd be wrong. If you are survived by at least one parent, you're going to be splitting that up between the parents and the spouse. So in North Carolina, the spouse is going to get the first $60,000 of personal property, and they're also going to get half the remainder. They're also going to get half of the real property. So you may be thinking, what happens to the other half? Well, if you have a parent, one or two, they're going to be taking the other half of the personal property, the other half of the real property. So the way that you do away with that, you take away the default rules, is creating your own rules. So you do that in North Carolina through a will. So if you want your spouse to be the 100% beneficiary of your estate, you need to name them as the 100% beneficiary of your estate in your will. Likewise, for medical decisions in North Carolina, there are defaults for who gets to make the call as to medical treatment if you're incapacitated. So if you want to set out specific people to make that decision rather than relying on the defaults, you're going to set that out in a healthcare power of attorney. You're also going to enable those people or that person to coordinate your care with physicians through a HIPAA authorization. You're also potentially going to be setting out your wishes for life prolonging measures or end of life care through what's called a living will or an advance directive. So I recently posted a blog post about this, but the Cary case in Florida. This was a case where a woman, Terry, suffered cardiac arrest, and she lost consciousness for quite some time. And by the time that she was resuscitated, she had been deprived of a lot of from oxygen to her brain. So she lost a lot of her cognitive abilities, and in fact, she was in a persistent vegetative state for quite some time. Her husband made the call to have all life-prolonging measures terminated because he didn't think that she would want to be kept alive in that sort of state. Well, her parents disagreed with that, and Terry did not have an advance directive that said otherwise. So what could have been, a decision that she made on her own prior to having that incident, it ended up turning into quite prolonged litigation and even political issues. George W. Bush even signed some legislation that was meant to prolong Terry Schiavo's life. Ultimately, the court sided with the husband and allowed for the life-prolonging measures to be ceased. But that's not what you want to have happen to your family. You'd rather make that decision ahead of time so that they're not making the decision themselves, or so that they're not arguing over it. Even if it was what you would have wanted, nobody's to know unless you actually set it out in an advance directive or living will. So those are usually what a young married couple will need: is a will, healthcare power of attorney, and an advance directive, and that's kind of the minimum. Things get a little more complex from there as you add assets or as you grow your family with kids and those sorts of things. But as far as young 20s, mid 20s, late 20s, just a young married couple, that's what they would need.